Good day. Have you ever imagined on what is happening in our court proceedings? Have you ever think of what is happening between the suspect and the victim inside the court proceedings? Is it really necessary to protect the suspect even if he or she violated the law? Is it really necessary to protect the victim and proceed in a court proceedings? What are the kinds of judicial assistance that the court was given to the victims? Is it really that reliable for them? Or is it really that enough for them? In this video, we will tackle all about the judiciary assistance on victims. It states here that the judiciary must be an impartial entity that oversees the program of a criminal action. Take note of the red note here. Judges should weigh and protect the rights of all parties involved in criminal proceedings. All of the parties in the criminal proceeding must be treated equally and weighed properly, without any form of bias. It states here that judiciary assistance on victims. Number 1, respect and recognition for victims. Victims and witnesses are provided with information regarding their rights and prerogatives in such as matters as the physical layout of the courthouse, witness fees, compensation funds, and other available assistance. Second is the court administrators establish the reception area and provide victims and witness with information about public and community services. It states here that respect and recognition for victims. What are these? What are the respect and kinds of recognition for victims? It states here that the victims must know the courthouse on what is happening inside the court, or the places or the parts of the courthouse, the witness fees, all of the compensation funds, and other available financial assistance. All of this must know in a specific victim. Court administrators, in the second bullet, establish reception area and provide victims and witnesses, again, equal treatment as we can see. Both victims and suspects and witnesses and all of the involved in a specific parties in a court proceedings. Court administrators establish reception area and provide victims and witnesses with information about public and community services. These are all the things that the victim should know. All of the information about public and community services. Second thing, providing victims with information, as I have mentioned earlier, about the compensation fees. This time, providing victims with information. What kind of information is this? Victims should be able to obtain from appropriate court personnel information concerning the status of their cases. These are the kinds of personnel that is handling the status of their cases. For example, this is their lawyers, the personnel involved in the court proceedings. If requested and if possible, appropriate officials should give victims of serious crimes timely notice of the release of the defendant from pre-trial and post-trial custody. All of the ways and all of the kinds of the trials and post-trial custody are the part of the in-court proceedings. It is the part 1 and the part 2 of a criminal proceedings. If requested and if possible, the official should give the victims a notice before the post-trial and pre-trial will be happen. In case the victims of a serious crimes, for example, victims of a serious crime will timely notice on when will pre-trial and post-trial custody will happen. Third one is special services and support. Separate waiting areas for the defense and for witnesses for the prosecutions, including victims. As we can see here, this will tackle all about the victims and the witnesses. What is the importance of separating of their areas? This is to prevent harm, danger from one another, and to prevent changing of information during the post-trial and pre-trial custody. Because when we do the pre-trial and post-trial custody, the defense of the witnesses, victims, and suspect must separated to prevent bias and to prevent planning of any malicious activities from both parties. Next is interpreter and translator services for victims and witnesses while they're in the courthouse. This is also important. Wanna know why? Because if a specific victim or witnesses or suspect only speak a language of Ilocano, Ilonggo, Bisaya, and any other kind of language in the Philippines, but the only valid in the courthouse is English, so the interpreter will proceed the translation of what will the victims or the witness will gonna say. Next is an on-call system to minimize unnecessary trips to court. On-call system, as we have known, is the calling of employees who has been available in a courthouse. This is also happen in a court proceeding because to minimize the unnecessary trips to court. Next is the expeditious return of evidence. What is expeditious? Expeditious is the efficiency or the speed of a specific evidence to return. Informing the public of the importance of supporting the participation of victims and witnesses in a court proceedings. This is the thing that we have seen in the court proceedings. The specific employee or the specific personnel inside the court will give the public what will be the importance of supporting the participation of victims and witnesses in court proceedings. This is the stage where the specific personnel will tell the public on what will gonna be happen inside the court proceeding. What are the rules that they should know and what are the rules or what are the things that they will not do inside the court proceedings. Crisis intervention, counseling, and other support services for victims. These are also the things that the judiciary will give to the victims. Crisis interventions, counseling, and other support services that will support them throughout the court proceedings. The last one is the child care services for victims and witnesses. Child care services for victims and witnesses. Example is the victim that has a child, witness that has a child, suspect that has a child. The judiciary or the court will make a service for the child and the family of both parties. This will be able to protect them when the criminal and the court proceedings or the judiciary proceedings is happening. Next is the ordering of restitution. Wherever possible under the law, judges should order restitution unless there is an articulated reason for not doing so, regardless of whether the offender is incarcerated or placed on probation. What is restitution? Restitution is the recompense of injury or loss. Restitution is, for example, I was ordered to pay 60 pesos in restitution. Restitution is what is something that has been stolen to the owner. For example, is the victim in a court proceedings. Unless the restitution happened, unless there is an articulation for not doing so. Next is victim participation. This includes pre-trial release or bail hearings, the scheduling of court proceedings, continuances or delays. Judges should state on the record the reason for granting a continuance, plea and sentence negotiations where these are conducted, sentencing, victim offender, mediation where appropriate. As I have mentioned earlier, these are the things that the victim should know. When is the schedule of a court proceedings, the request for continuance or delays of the specific suspect or the victim, the plea and sentence negotiation of the suspect, The victim should also know about this. The victim-offender mediation were appropriate. Next is the person accompanying victims. To encourage victim participation, victims should, wherever possible, be accompanied in the courtroom by a supportive person. This is the person that I have been talking about earlier. This personnel is the one who will protect the victim. Victim impact statement prior to sentencing should be encouraged and considered. All of the victims, all of the statements that has been released in the victims must be encouraged and considered in a court of law. And victims or the victim's family should be allowed to remain in the courtroom. As we have seen in a movie or a teleserie, whenever there is a court proceeding, the victim that is in the front, and as we have seen in the back, we can see the family of the victims. This is the proof of the victim's family should be allowed to remain in the courtroom. Next is the protection of victim. As I have mentioned earlier, all of the things that I have mentioned are the information on what are the rights of the victims to do in a specific courtroom. Now, let's proceed to the protection of victim. Protection of the victim is the expediting of trails in case involving particularly vulnerable victims. These are the ways to protect the victims. Victims, as I have watched a movie, many kinds of movies, victim is the one who will receive a, what do you call this? A justice. Victims must be the one who receive the justice. And with that, with the help of criminal proceedings, the victim will receive his or her justice with a perfect or the successful criminal proceedings or the court proceedings. Next is encouraging specially designed or equipped courtrooms to protect vulnerable activities. Permitting the use of videotape depositions in case involving vulnerable victims. These are the evidences that the victims involved. Allowing vulnerable victims to have an individual of their choice accompany them in a closed juvenile proceedings, closed criminal proceedings, or in-camera proceedings. If a defendant is conducting his or her defense, preventing the defendant from directly questioning the victim. The defendant is the one who will question his or her own defense, preventing the defendant from directly questioning the victim. That is most probably not valid in a court proceedings. There is the steps to question the victim. This is not a thing that is directly questioned to the victim, even if he or she is done in his or her statement. Next is architecture and use of space in court buildings. Efforts should be made to create separate facilities, in particular separate waiting rooms for victims and other witnesses in the prosecution, and for offenders and other witnesses for the defense. In new and renovated buildings, plans should allow for separate waiting rooms and toilets. These are the things that future thinking of a courtroom. So what will the architecture and use of space in court buildings will help the courthouse to become more effective in a court proceedings. As we can see here, it states that the offenders and other witnesses or any person who involved in a specific party in a court proceedings must have a separate waiting rooms and toilets. What is important of this one? This is important in preventing harassment of all kinds by one party or another. As I have mentioned earlier, this is the thing that they should know, because if we place the victim, the suspect, the witness in a single place, we can see a lot of disadvantage in that. Some will do some harassment or any other kind of harassment that will be happen. The importance of this one is to prevent harassment of all kinds by one party or another in a different parties. There should also be a room set aside for distressed witness to retire to after giving evidence. This is the one who is the witness that gives the evidence who is in distress. O kumbaga, ito yung lugar na kung saan ilagay yung isang distress witness after niyang magbigay ng isang statement. This facility will allow time for the person to recover their composure before returning to the courtroom or leaving the building. In addition, refreshment stands should be provided, as well as special facilities for children and people with disabilities. This is not just all about both parties, but also the people who involved in a courthouse. The architecture and use of space in court proceedings will also prioritize about the children and people with disabilities inside the courthouse. Judges are empowered to sentence offenders for the offenses for which they have been convicted. It may be important that judges include information regarding the impact of the crime on the victim in their assessment of appropriate sentences. In some jurisdictions, the victim is a party to the proceedings and can contribute such information directly. In other jurisdictions, however, this information must be provided through a prosecutor-based victim assistance program. A probation office or some other official source in some of these jurisdictions, it takes the form of a special victim impact statement. Such victim impact information is often the only comprehensive assessment of the injuries caused by the offender available to the judge. What are the examples of specific approaches to enhancing the judicial response to victims? I have mentioned an example here. In Canada and many other countries, laws allowed for videotape testimony for certain child victims. For the example, the victim is the child. In Canada and many other countries, laws allowed for videotape testimony for a certain child victim. A support person is permitted to accompany a young or otherwise vulnerable victim or witness. Personal cross-examination are restricted and both mandatory and their discretionary publications bans exist. This will happen if the victim is the child. The victim should accompany a young or otherwise vulnerable victim or witness. Personal cross-examinations are also restricted and both mandatory and discretionary publications bans exist. In the United States, and the example earlier is the Canada, now proceed to the United States. In the United States, a special children's court was established in California in 1992, designed specifically to meet the needs of children going through the court process. In the United States, a special children's court was established in California in 1992. This is also designed to specifically to meet the needs of the children going through the court process. So in this area or this era is the date that has been established in California in 1992 to do what is the thing that to do the special children's court. What are the basic information? What are the basic importance that the United States build this one is to specifically meet the needs of children going through the process of the court. The building small courtrooms are less intimidating to children than traditional courtrooms. So, as we have seen, the courtroom is, as we have seen in the movies, many courtrooms is that many courtrooms is big. Many courtrooms consist of how many seats, how many persons, but in United States or the special children's court, the court is less intimidating to children if it is small than the traditional courtroom, so that every victim, especially children, will not be intimidated in the big courtroom inside a criminal proceedings or the court proceedings. Safe friendly and private play areas. These are the things that is inside this the special child courtroom. Family visiting rooms, exercise areas, and conferences rooms are available for children to meet their attorneys, social workers, or other care providers. Special initiative of the court include counseling services for children and their families, training and internship programs, and a child parent art program. As we have seen in this world, there are a lots of courtroom, or there are a lots of different courtroom in a specific country. There is a traditional courtroom where the courtroom is big. There is also a child courtroom where the courtroom is small. For what? For the less intimidating of children. The courtroom of the children composed of play areas, family visiting rooms, so that the children will not be intimidated in the court proceedings. Actually, all of the parties involved in a criminal proceedings, either you are child, adult, either you're a child, adult, or teenager, everybody is treated equally inside the court proceedings. No matter you are a suspect, in the eyes of the law, you convicted or you violated a law. But not all the suspects are really suspect. Some of them are also the victim of mistaken identity that is pursued to them. Some of the victims are not just a victim. Some of the victims are not really a victim. They are playing the role of being a victim because they're a victim. Some of the suspects are not really a suspect, but they are a suspect in the law because our law enforcement catch him or her to proceed in a court proceedings. Everybody is treated equally inside the court proceedings. A lot of trials and decision makings are happening in a courtroom. It is not a biased thingy that is who is the one who will gonna pay the judge or the head judge. That's not it. That's not it. That's not how the law works. That's not how the justice works. The justice works in a proper proceedings. And with that, I leave you with the saying that who is the Agatha Christie. Agatha Christie is the one of a philosopher that states about the victim. The victim's stance is a powerful one. The victim is morally upright, neither responsible nor accountable, and forever entitled to sympathy, which is always right. Victims always entitled to sympathy. Victims always want to have a person who will always be with them. The victim is powerful one. Because without the court proceedings, without the victim, there is no court proceedings, or there is no criminal proceedings in a court of law. Victim is always the one who will proceed in a criminal proceedings. Victim is the one who will decision to stop, or who will decision to continue the specific case and to proceed in the law. That's why Agatha Christie said the victim is a powerful one. The victim and the suspect will always weigh equally in a court of law, even if the victim who wants the criminal proceedings. In a court of law, either you are a suspect or a victim. If you are a suspect, then there must be an evidence that you really violated the law. Then if you are a victim, then there must be an evidence on why you called the victim. Because the injuries that is been given to you by the suspect, or any loss, harm, danger that is been given to you by the suspect. Criminal proceedings is long. And every criminal proceedings, especially in the Philippines, will always be equally. But I believe in the saying of my mom, right thing to do is to do right to the people. The eyes of the law will always seize you, even if you are sleeping, daydreaming. The law is there. The rules are there. Again, I hope that you will listen, and I hope that you will learn about something in my reporting about the judiciary assistance of victims. And always remember that everyone must be treated equally. Because in the Section 1, Article 3B on Law Fights in the 1987 Philippine Constitution, as we have known, it's the means of that the provisions speak of due process and the protection of all individual, or the equal protection of all individual. And that's your right. That's your right as an individual. Again, thank you for listening to me. I'm Ayasa Evangelista for BSC 210. God bless and good day.